finished and watched this course. If you are watching this as a recording, please let your consultants know. That's the only main requirement I'm asking because this is going to be a big information dump. And this is just information for you to get familiar with. And if you need help later on, then seek your advice of your system consultants, directors, or I always make myself available if your system wishes you to contact me, because I dig into it a little bit more than some of the others in the state. So however you're comfortable, but definitely go through your systems first. But we are going to actually start with something a little different. I have two presentations. One is basically the law, the overview, but also because this has been such a issue for the state and the nation, I'm going to go through the talking points for challenge materials. So you kind of have some ideas. What I do is utilize just Constitution, Declaration of Independence, and Kansas Constitution. So that is what we are actually going to start with. So I'm going to change out and go to my PowerPoint. Maybe. Did I look good, Robin?
Right, perfect.
All right. And challenge materials, here we go. It's basically the first thing you definitely need to know for your library is, do you have a mission and or vision statement? Mission, just as really quick definitions, definitely not in-depth definition. A mission is where you are now, and a vision is where you wish to be in the future. And also within, if you do have these, hopefully you do, does the wording need to be changed to state whole community rather than just community? That way it's specific that you are reflecting your whole community. So sometimes that can be debatable on how wording is in the realm of legalese. One of the things that we always try to encourage that libraries were created to be neutral places. That's how I learned when I was coming up through library school. We will have controversial titles. The newer terminology that is being put out there now is that it's to be called that libraries are nonpartisan. We don't affiliate with any party that might be out there. So that's why they want us to start using nonpartisan now. So when you're looking at some of your, uh, yeah, come on, let me put that on Do Not Disturb. When you're looking at some of your terminology within your policies, that's something you might want to change if it says neutral. Basically, it's stating that if a patron comes across something they do not like, they don't have to read it, listen to it, or watch it. A patron can always put that thing back on the shelf. They can pass it by until they find something they do like. Also, when you're looking at this, libraries operate on how, and this is just a short list, how people deal with their daily lives, your patrons. You have medical information. You let them explore different ideas about different religions, control of their money, making financial decisions, starting a business, gaining knowledge about a political party. It could be any political party, not just the main two. Learning about history, or what some people don't realize now, which is just as important, is the mental break where you can provide them a break from their daily lives. You are there for their leisure as well. How a library operates, some other terminology you can use is libraries are supported by tax-derived funds, and a library is meant to reflect their community. Doesn't matter their culture, religion, social, economical background, or the way they choose to live their lives. You're there for your whole community. And everybody within your community are paying taxes. The library offers different points of views. You have different religions, cultures, political views. Always express that if one point of view is challenged, it weakens the library collection as a whole. And anyone at any time can come in and challenge anything within your library, and it would be susceptible to what has been done previously. So anything can be challenged makes your library collection weaker. Now we're going to get into some of the stuff that covers into the Declaration, Constitution, and the Kansas Constitution. One of the things I always say, deal with facts, deal with law, don't give opinions. That's where you're going to get in trouble when you deal with opinions. But we have this quote from the Declaration of Independence. We hold these truths to be self-evident that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. Many look at the term creator and have said that that means we are a Christian nation. Well, in actuality, not necessarily true. Creator is used because it is a multi-use term for any head deity of any religion that the cultures on our planet have. Whether it's a tribal nation, over in India, over in Japan, China, South America, wherever you might be, they all have their creation stories that have their head deity, which is the creator. Also, within just our own religion, we have different sects, basically. We have Methodist, Protestant, things of that nature. God is used in the English language, but the same God is used in Hebrew, but it's pronounced Yahweh. And if I mispronounce it, I apologize. Might be Yahweh, I'm not completely sure, but there is a difference, even though it's referring to the same head deity. Also, when it comes to the pursuit of happiness, this includes an individual, but as well as a family. From the Constitution, we the people of the United States, in order to form a more perfect union and establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution of the United States of America. Sounds pretty simple. Pretty much is, depending on how you interpret things. Interpretation of ensure domestic tranquility is to respect everyone's ways of living, even if they don't line up with yours. Secures the blessings of liberty. Definition of liberty is the state of being free within society from oppressive restrictions imposed by authority of one's way of life, behavior, or political views. So yes, ensure domestic tranquility is an interpretation. However, the definition of liberty is not. Also, it reflects the First Amendment in our Constitution with free speech and religion. Make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press. Most everybody's familiar with that. I'm not going to go into the press. We realize that's relating to books and print of any type. It's also relating now to pressed musical and audio, but also religion is to allow any person or group to choose who they worship and how they choose to worship. Now we're going to, and I know I'm going quick. There's a reason why, because I don't have much time, so I apologize. Going to the Constitution of Kansas. Section 1 says all men are possessed of equal and inalienable natural rights, among which are, with our life, liberty, and pursuit of happiness. Sounds very reminiscent. Section 2, this is an interesting one. All political power is inherent in the people of all free governments are founded on their authority and are instituted for their equal protection and benefit. To me, the key words in this statement is the instituted for the equal protection and benefit. We're supposed to be equal to all people, not just one or a few. Section 7 of the Kansas Bill of Rights and the Constitution is, nor shall any person be compelled to attend or support any form of religion. Most of your challenges are going to be religious based. That's just the nature of what most of them will be on. Okay, when a patron does come to you with a challenge, when you're visiting with a patron or they are at a board meeting, you need to remain calm, If you choose to talk, like I said before, state only facts, laws, not opinions. That way you don't get yourself in trouble. Pay attention to the patron's complaints and don't put on air that you are placating them. That will definitely turn them away from you automatically before moving on. Basically say thank you for the patron for taking the time to address the board if they are at a board meeting. If the board wants to discuss it further, it is recommended that they do not do so at that current meeting. They will say that if they wish to address it further, they will place it on the next month's agenda. This gives them time to research everything and make learned decisions and statements. That way they don't trap themselves in something that will get them in trouble by what they're saying. Now, that's how you want to meet that. Now, the Supreme Court has given us the three-step test with the 1973 Miller versus California, or three-pronged obscenity test. This is brought about, like I said, in 73. The main thing that to any average person applying contemporary community standards, the work taken as a whole appeals to the prurient interest, which was later defined by the court as having the tendency to excite lustful thoughts. Also, that the work depicts sexual conduct in a patently offensive way, and that the work, taken as a whole, lacks serious literary, artistic, political, or scientific value. So it has to meet those tests. If it meets one of those, you're basically, by law, the Supreme Court says it should stand where it's placed. Within the Kansas law, we have two statutes that really fall underneath this that reflect the U.S. Supreme Court's decision. That is 216401, which is promoting obscenity, and 6402, harmful to minors. If you haven't heard about that, you might want to look up the whole statutes. If not, here's a brief. Under 6401 on obscenity, section F1A, the average person applying contemporary community standards would find that the material performance taken as a whole appeals to the prurient interest. Then in B, the average person applying contemporary community standards would find that the material or performance has potentially offensive representations or descriptions. Then in C, taken as a whole, a reasonable person would find that the material or performance lacks serious literary, education, artistic, political, or scientific value. So you can see that those are basically echoing what the Supreme Court decided in 73. Some defenses under 6401 is section G. It should be a defense to a prosecution for promoting obscenity or promoting obscenity to minors. Under section 2 of that section, defendant is an officer, and I'm going to skip here to the red, public library, and the alleged obscene material was acquired by such library and was disseminated in accordance with regular library policies approved by its governing body. This is one area, and I think even the next law, this is one area that some of our legislators are wanting to strip out of the statutes. When you get to harmful to minors, again, it goes into section D2A about the average adult person applying contemporary community standards. Pretty much the same wording. I'm not going to go through all of it. Section D2B, again, adult person applying contemporary community standards would find that the material or performance depicts or describes nudity, sexual conduct, excitement, sadomasochistic, say that fast, abuse, and in a manner that is potentially offensive and prevailing standards in the adult community with respect to what is suitable to minors. And then in C, a reasonable person would find that the material performance lacks serious literary, scientific, education, artistic, or political value. There are some defenses, but before I go back, you notice that in both cases in the statute, it says contemporary community standards. That's putting into effect of what is the contemporary standards of today, not in the past. However, you also see in this section D2B under harmful to minors, prevailing standards in the adult community. your community standards might differ from a different community standards. So in the eyes of the law, your community, if they want to challenge something, could have a reasonable standing because within their community, this is what they wish and desire as a majority. Okay, some of the defenses, notwithstanding of the statute 215204 and amendments thereto to the contrary. And under 2, the defendant is an officer, director, trustee of a public library and is acquired by a public library and was disseminated in accordance with regular policies by the governing body. Also, culpable mental state also comes involved. That was that statute I just mentioned in the previous slide as 5204. This basically is proof of a culpable mental state does not require proof of knowledge of the existence or constitutionality of the statute under which the accused is prosecuted with the scope of or meaning of the terms used in that statute, that the accused had knowledge of the age of a minor, even though age is a material element of the crime with which the accused is charged. So basically, if you had knowledge that they were a minor, you had knowledge that it was against community standards, you had knowledge that it could be considered obscene because obscene is not protected in the Constitution or by law, you could face liability issues with your library and yourself. I know that was a fast and quick rundown, and I apologize, but we don't have much time. I'm going to pause while I'm changing out slide decks. And you can read the little statement I came up with for the end slide before I do, but are there any questions? I know I was rattling off fast, but are there anything there, Robin?
I've got nothing in the chat. The only thing I was thinking of is I went to an Every library while you're doing this. I went to an Every library session where they said about 4% of challenges actually involve moving the book. People are human. These challenges do actually sometimes mean that the book is reconsidered and it's either moved or removed or whatever, but it's about 4%. It's not a lot, but that's one of the reasons why we have this challenging process, is because occasionally we make mistakes.
And it's a lot of times when you introduce the actual form for them to fill out, they might back down at that point, put their name on a form. Some libraries, depending on if you have a form or not, it's suggested that you have a template form. If not, if your board just says they can write it up in a document, which could be a letter, if that's what your policy says, that's suffice to initiate a challenge. And then you need to have within policies how that challenge is conducted. Who reviews it first, who reviews it second, who has the final say. And then, of course, as with anything, as long as if they have enough money and they want to file litigation, they can. Basically, with anything I'm talking about, because I've been involved with a couple of litigation suits, the library board is involved. You as a director are personally named on the suit, so have fun with that. Plus, more times than not, your governing entity is named as well. So if you're a city library, be your city. If it's a county, it's your county commission, and so forth. So it does involve quite a few people. So be aware of that. Also, liability insurance, true. Also, have on, most libraries can't afford an attorney on retainer. See if there's somebody within your community that would be willing to work with you on a case-by-case basis. Some of them might give it to you at a discounted rate or even pro bono, and so they could take it off their taxes at the end of the year. It might be a way to offset some of the expenses if you find yourself in litigation for any reason, not just this. Oh, and school libraries, if you want to share this with your school librarians, technically, I can't say that it will work because they actually fall under the Department of Education and their guidelines there. So they will need to look at those before they can actually see what they can and cannot do, because they are specific on what they can and cannot do per grade level. No. All right, are we ready to do the flash forward on this next section? Here we go. All right, just briefly going into the legalese stuff. Statutes are placed so individuals have a place to reference what it can be done legally, whether it's within the state or nation. A statute will not necessarily guarantee what answer you're looking for. They're written to be vague. This is done so your attorney generals and your defense lawyers have some wiggle room to interpret laws and make deals. The court system is where the question of a law is decided. The courts can do different decrees. They can leave it vague, they can make it more strict, or say that the interpretation is on a case by case basis. So your courts control what your laws say and when challenges arise. Traditionally, not going to say we're in a traditional world anymore for quite a few number of years, but traditionally a bill was introduced in the House, but now a senator or governor or president can introduce bills as long as they have the support to push it forward. Committee work is usually done if the body wishes to take up the bill. If they wish to put it onto the floor, they will be debated on the floor. Once it passes the House or the Senate, it goes back to the other presiding House or Senate for their looking over. And if they all agree eventually on their maneuverings and mechanizations, then they pass it and it goes up to the governor's or president's desk for signing. For the state of Kansas, the governor can either sign the new law into effect or they can veto it. To override a veto, it takes 2/3 vote of both houses, not just one, but both. And there are times where bills are introduced. We've seen this several times. And if you've been around in the director chair for a while, you'll see it as well. Bills can die in committee, but they can always be brought back up as well in future legislative sessions. The majority of the statutes for libraries will be found in Chapter 12. There are others that are outlier statutes that do involve libraries just because of the way we operate, but that is where the bulk of it will be. Most current statutes will be held at the Kansas Office of a Reviser of Statutes, and that website there is the link for it. So you can utilize it, and basically that will get you the most up to date. And on that site, you can search by the statute number, or they do also have a text search. When I'm talking municipalities, they are usually considered county, township, and corporations, or incorporated city. Governing body, that definition is 1218 as well. They are your city board, county commission, such forth. Sometimes you'll hear me say governance. That's just my vernacular for governing body. Your official head, it's also defined by the statute 1218. They're either your mayor, the chair of the commission, township, and so forth. I'm going to jump into these and go fairly fast. The city is a 7-member board with one ex officio being your city mayor. So you have a total of 8 members. For a quorum, you will need, what would that be? 5 members to have a quorum. Your mayor has the same duties and powers as any of your board members, and they count towards your quorum. So if you do not have those 5, you would have to call around, and you can, if you have a provider within your bylaws, which most should, you can get them by telephone, or if you do provide the Zoom links, you always have an alternative way to get board members to your meetings. A person can serve 2 terms of 4 years if they are eligible. Once they are finished with those 2 terms, they have to set off for 1 year, and then they can come back onto an additional term. If they are completing an unexpired term, the rest of that term does not count towards their 2 terms. So if Paul had 2 years left on their term, Rebecca came in and filled in, Yes, she has 2 years as a board member, but then she can be reappointed by the mayor, by the and approval of the city council. And that's the beginning of her first term of 4 years. And then at the end of that, she could be reappointed again for another 4 years. So Rebecca could have a total of 8 years on your board, or excuse me, 10 years on your board instead of 8. So remember that when you're tallying up board member terms to make sure where they fall. If you are a county, you are a 5-member board. You have one ex officio who is the chair of the county commission. So you will need 4 members here to have a quorum as well. The qualifications of terms are the same as city. For a township, it is a 5-member board as well with the ex officio. Excuse me. They are appointed by the township. The ex officio is part of your quorum. So you need 4 again. And this is the same way. They have the same qualifications, 2 terms of 4 years, then set off for 1 year to come back on. Regionals are a little bit different. They are a 6-member board and 1 ex officio, total of 7 members, but it can be more. The library board is appointed by the official head of each participating county or township. So depending on how many counties or townships are involved with this board will depend on how many board members you will have. So if you come, and they have to have equal representation. So if you see on that third point, if you have 3 townships, the minimum member count will be 2 from each township to meet the 6-member standard. And then after that, your ex officios of each township are also members. So there's 3 more additional members. So you just now went to a 9-member board. Now, the fun thing about regionals, once you have finished your terms, by statute, there's no way for that person to come back onto your board. If for whatever reasons you have a population hardship, you might try to claim that. And if it's ever challenged, you would have to prove that in a court of law and have the judge side with you. But by statute, they cannot serve except for their 2 terms. Kind of unusual, but why it's different from the other 3, I don't know. The other thing, the other library that we have in our world is district libraries. This is completely different. You can set up your township, or excuse me, districts. You have to buy not less than 10% of the qualified electors of what the district is going to be composed of. I'll just let you read the rest of that moving forward because they have to make a vote. Most everybody that's here will already be a district, so I'm not going to go through every little thing to save on time. Such a library district, through its governing body, is hereby authorized to do an annual levy. So everything there's the same as any other board. You have a 7-member board. They are elected, as it states. So your quorum has to be 4 members. Successors shall be elected in the manner provided for electing members of library boards. Usually that is held at their annual meeting. Whoever shows to their annual meetings is usually considered the quorum. They nominate who the next board will be, and then they do a vote. Technically, that's how it's supposed to be. In reality, I'm not sure if that's actually followed. And then the last caveat, that last bullet point, the law is silent on how many terms a board member can serve on a district library board. With it being silent, that means they can be there for an indefinite period of terms. And nobody has challenged that yet. So right now, if they keep getting elected for another 4 years, you might have that person for 30 years if that's how long they last. So you hope not, because you like to have a change of board members, just to have new ideas. But it all depends on your electors and who they elect, and if it's ever challenged in the future. All right. Any questions? Well, I'm kind of at a pause.
Nothing in chat.
In the chat, okay. For your library board and meetings, this falls under 12-12-24. Basically, the first point, the board shall immediately after they're appointed and annually thereafter meet and organize the election of a chairman, or really it should be read chairperson at this point in time, but sadly it does not. A secretary and a treasurer and such other officers as they may deem necessary. So by statute, you only have to have 3 officers, but many of your boards will have a vice chair, if not a second vice chair even. The board needs to also fix a date and place and time for where you are meeting so the public knows that they can attend. If you call for a special meeting, the chair can do so. That person is the only one that has that power unless the majority of the board has a written request to the chair to call a special meeting, then that can be called as well. Within a special meeting, if it is called, unless waived, they need to be notified of us. Your board needs to be notified before 2 days prior to the meeting. The only topic that can be discussed in your special meeting is the topic designated on your agenda. You cannot go outside of that topic. If you are talking about, oh, you're needing a new air conditioner, so and it's an emergency, so you call a special meeting. If they start talking about, well, what about we might need a copier too? You can't do that. That's not on the agenda. If you stated it was just to purchase a new air conditioner, that's what you have to state. If you leave it a little bit vague and say purchasing of equipment, gives you a little bit of wiggle room. But if you are very specific, you have to be specific on what they discuss within the meeting. The board can make and adopt your rules and regulations to administer your library. They can purchase and lease sites, lease and erect buildings. So that's not too uncommon, but they also have to receive the approval from the library's municipal governing body before they do so. So they can't just go out and do it. They do have to get approval. Acquire by purchase, gift, or exchanged items. You do this all the time. Deemed necessary by the board for the maintenance and extension of their services. Employ and remove a librarian and other employees and set compensation as the board deems necessary. And then they also get to maintain, if they so choose, a traveling library. So if you have a bookmobile, that's usually what this is involving, they can do so. They can also contract with other established libraries from different municipalities. The most common you will probably see is when a school has lost their librarian and they want the local library to come in and run the library and staff the library. You go through all your MOUs, contracts, whatever you need to do. A lot of them are just MOUs. That's where you'll see a lot of this. Usually you like to have it as a contract, because like I said, that's what's in statute. The wording is contract, because the library will be paid for managing that other library, whether it's in the school or it can be in the next town over. They can do so. The board can receive, accept, and administer funding appropriate or granted to the library by state, federal, and other areas. These are your grants. Pretty much what that means. You're able to accept grants. Receive and accept any gift or donation to the library and administer the funds according to any provisions from the donor. If no provisions are given, the board shall do what they wish with said money in the best interests of the library and the community. I know I'm paraphrasing some of this stuff. I've done this so often. That's just me. Sorry. Let's see. You get to make annual reports to the state librarian and a municipal governing body before January 31st, before disbursements will come back again to you. However, I can almost guarantee you the majority of librarians and library boards do not do this anymore. The one that you will be most familiar about will be the state survey, and that'll be coming up here in January. But some libraries still require that you do an annual report just for the library, that you report to them and have available to your governing body if they request it. Just depends on how your board operates your library. Your board can place money received from other sources other than tax levy in support fund, or funds are placed within the tax levy money is credited unless the grantor or donor directs how or for what the money shall be handled for. This is if you get cash. If the donor says you can only spend it for this reason, then you can only spend it for that reason. If they don't put any, as I say, strings attached, again, the board decides how it is needed to be used to best help the library and community. If that's investing it to get a better return, it could be investing it. If it's spending it to improve the library in some form or fashion, that's viable as well. Okay, 1227. Libraries established under and governed by the provisions of this act shall be free to use the inhabitants of the municipality subject to reasonable rules and regulations. This is your policies and bylaws that you operate under for your library. The board may exclude from the use of the library any and all patrons who shall willingly violate such rules. This is your authority to say, you know, you've been a little disruptive today. Let's try again tomorrow. Or it might be a week suspension, however you want to do it, that your board deems necessary. Also, the last point, the library board may extend the use of the library to non-residents of the municipality in exchange of books with any other library. Usually this meant interlibrary loan. It can mean other arrangements as well. Depending on how your system operates will depend on how you might qualify for different things within the system scopes. But an example of this is we have a Cimarron City Library in our area is in Gray County. We do not offer any extra services if they go outside of their service area. All we do is say you provide for your city. That's it. Well, they have decided that any county that is adjacent to their county, they can also have memberships within their library. That's well and good, but it doesn't mean anything in regards to the system. Doesn't get them any more or any less. They're just providing it for additional people. A lot of libraries will do this to augment their statistics to help out in that regards. All right. Any questions before we go into coma? You might be in a coma by this point. I don't know.
Nothing in chat, so.
Okay. If I do go too fast and blubber, please stop me. I will go back. I realize we are going fast. All right, for coma, this is where it gets fun. There are two requirements. Meetings must be open. Notice of meetings must be provided to those requesting notice. Quorum is over 1/2 of the body. A body of your board is the seats, not the people. So even if you have a vacant chair, you still count that as being needed for your quorum. If you meet your quorum, you're golden, no problem. If more than 1/2 of this is the fun one, the very last point. If more than 1/2 of your board is at an event and they sit together, technically in the eyes of the law, this is considered an open meeting. And they need to actually open up a meeting and somebody has to take minutes. This happened at Kearney County. We have 3 county commissioners. I went to a town hall for senator. 2 commissioners showed up. Right behind them was the county clerk. They opened up the meeting. The minutes just said they attended the town hall meeting for such and such senator. Then when they left, one of them left. She wrote, meeting was adjourned, and that was it. But because 2 out of the 3 were there, she had to be there and record. So to get around this, just kind of comment to your board members. If you see that you're in danger of meeting the quorum statute requirement, try to spread out a little bit so they don't meet that, because it only takes one person that wants to be the fly and says, we're going to stir things up. And that has happened many a times in libraries. It's just one person that starts things rolling. So to avoid that, that's what's recommended. Just let them know that they need to separate themselves out so they don't accidentally violate the Coma Act.
And then while we're switching slides here, we have a question.
Okay.
Does a special meeting have to be posted, advertised to the public?
Technically, no, but it is really suggested that you do so. Because the only ones that have to be noticed for a special meeting are your board members 2 days in advance. It is recommended to always post 3 days in advance for your public if you can. Post it. The minimum requirements for posting, so you just slap a sign on your library door or on a bulletin board that you're having a special meeting on such date, time, and place. You've pretty much settled that. There's no question. I'd rather err on the side of caution than not. That's just myself. But as you found out during the situation we had a couple of years ago when we had the shutdown, many governing agencies, because of emergencies, didn't have the time to put out notifications. They were meeting sometimes within 3-4 hours trying to figure out what to do. And the Attorney General waived a lot of those because it was an emergency. So technically, no, advised that you do if you can. So,
And then
anything
we do
else?
have, oh, another
Uh,
question came in too.
Okay.
How far away is different locations? Like a couple of people in between them, or?
They cannot be in verbal distance of each other. They cannot be able to carry on a conversation. So you take into account, I would say a good, let's say 8 feet. If they're going to have a conversation, they're going to have to be yelling at 8 feet, especially if it's at a ball game. So that's pretty much the requirement. Don't sit right next to each other. That's clearly, or a lot of times it'll be who's in front, who's in the middle, who's behind on the seats. That can be close enough to do a conversation as well. So always use probably about 8 to 10 feet just to be safe. Say, if it's you have a quorum of 4 and it's only 2 or 3, they haven't violated anything yet. Well, if that first person comes along, they either have to be mean and say, go sit somewhere else, please, or they say they just separate themselves altogether to avoid it. So it depends on how mean they want to be that day. So, but they cannot be within verbal distance to hold a conversation. So I know it's a
Thank you.
vague answer. I don't know, Robin, how many feet do you think it should be?
Yeah, I like your, too far away to talk, and that's going to be different in different meetings. Some meetings are loud, and maybe 5 feet away is too, but yeah, just too far away to have a conversation is a great rule of thumb.
Uh, Anything else?
Nothing in chat.
And the first question is kind of answered on the next slide there, as you'll see, about the special meetings being posted. It's common practice for boards to give 3 days. Special meetings don't have to be posted, especially if it's an emergency, but 24 hours is enough time if you want to do so. And again, we've already talked about you can only discuss what the special meeting is called for. All righty. During your meetings, the public has the right to be at your meeting. However, the public does not have the right to speak unless the board has a section for public comments within its agenda or the chair recognizes somebody to speak. Those are the two instances where public can speak. Now, I will sit here and tell you I've been to board meetings where people will just blabber out and say something without getting permission. And the chair just let it roll over. And I'm there biting my tongue because we at the system are just consultants. We are there just as you are at the board meeting. We cannot speak unless directed to speak. And I'm pretty stickler about decorum whenever possible. So sometimes people will just blurt stuff out, and you've seen it, especially when things get heated. Also, this is something that some people kind of get frowny about, but the public has a right to record the meetings, whether it's audio or video. However, the public is not part of an executive session. Your executive session only applies to your board. We'll get into an AG's opinion about that here in a moment. But whoever the chair invites into the executive session is also part of that executive session and no one else. As we go forward, kind of mentions what I just stated about specific individuals can be allowed into the special session. During that executive session, it is understood by everybody that is in there that any discussion that is held in there is private and privileged and is not to be shared. Your library board cannot make any decisions while in an executive session. And this is one that has recently changed within the last couple of weeks, so I apologize for not having an update. In most instances, a board member cannot be excused from an executive session. However, we have had a recent an attorney general opinion that states that if a board member has filed litigation against the board itself that they are a member of, and the board needs to go into executive session to discuss strategies or whatnot with their attorney, that board member can be excused because they initiated the litigation, so they are not part of the defense that the library could mount. So that is a very recent AG opinion that has changed. It's either within a couple of weeks or a month. And I've been swamped and I have not updated. So Robin, remind me to do that. I know you're not busy like me at all. Let's see. Here are some topics that can be discussed in executive session. Personnel matters of non-elected personnel, that's staff or you as a director. They could ask you to step out. More times than not, the director is asked to be included because you're giving an explanation of the situation. Consultation with an attorney for the body or agency, which is deemed privileged information between attorney-client relationship. Matters relating to employer-employee negotiations, whether or not in consultation with representative or representatives of the body or agency. I'll use myself as an example. I am under contract with this system. I went into negotiations with this system to renew my contract, which was done. So Robin, you're stuck with me to the end of 2027. I haven't announced that to everybody yet. You're the first to know here in this here, except for my staff. I'm one of the few that is under contract. You can ask Robin, that's not usually the norm.
No, it's not. I was looking for a thumbs up reaction, but I can't find one. So sorry.
Also within executive session, you can do confidential data related to financial affairs or trade secrets, partnerships, trusts. Excuse me. This one is one of those where if you're doing bids, a lot of times your boards will do sealed bids and we'll look at stuff that way. And that will be an executive session to discuss the sealed bids. If you invite the bidders to come and present, that is usually done within executive session because you don't want all of the people that are bidding on a project to hear each individual's bid, because that puts some of them at a disadvantage because the first person will say something that the last person can say, maybe I can readjust real quick on the fly. And unless they provided documentation, they really can't. But if they do not provide documentation, they could adjust stuff on the fly. It just depends on, and usually if a business is not provided documentation ahead of time, you probably don't want to deal with them anyway. My opinion. Put that out there. That's my opinion. Also, what you can go to executive session for is matters relating to actions adversely and favorably affecting a person as a student, patient, or resident. This is basically if you're talking about a patron, whether it's their medical conditions that you might be aware of, something that's going on with their account. If you're giving personal information, that needs to be an executive session. Let's see, preliminary discussions relating to the acquisition of real property can be held in executive session. But all, like I said, all decisions have to be in open session. This is the structure of what you would do for an executive session. One of your board members will make a motion to go into executive session, let's say at 7:30 for 10 minutes. Somebody will need to, and you will give the reason, in this case, personal issues. You'll have a second and motion carried. So the next time you go into your minutes, you will state the library board returned to the open session at 7:40. Now, if you need to extend the session at that point in time, either the same two or different board members need to make another motion to go back into executive session at 7:40 for additional 10 minutes to discuss personnel issues. Second and motion carried. Next time you come in to your minutes will be the board return to open session at 7:50. During your executive session, there is no minutes being taken. If minutes are taken and they are kept on record, they are now part of your open records and they are able to be accessed. For when you are in executive session, the board cannot go past the time given within the motion. You have to return at the given time. Again, as we've stated, if you need more time, you can always extend it. Sometimes it might be 3 different times. You never know. However, it's silent on when you come back into a session if you don't need the full time. If you do come back within a session early, because you didn't need the full 10 minutes, just state, obviously, within the minutes that the board came out of executive session early and just state the time that you came back into open session because they did not have any further discussion. All right, anything under executive sessions while we're kind of moving to a different topic? Okay.
Nope.
Not too bad on time. So, all right, this is one that some libraries will take advantage of, some do not. It just depends on your structure. 12.12.29 is the use of privately owned books or collections. The board can authorize the circulation of a privately owned books and collections. Usually this is done with either a contract or a memorandum of understanding. But the owner can lend the library books or collection within a timeline or open timeline. It just needs to be written up and both parties sign off on everything. The owner can require a fee to house their collection or materials within your collection. You will see this done sometimes at the university level where they will actually pay a family to house a collection just to have that within their university. The owner can require that the books remains within the library and not to be circulated. No damage will be done to the books, to include all your nice stickers and all that stuff. You will not affix anything. It's just for in-library use only, and nothing can be done to the books. The owner can request the collection to be returned when the term of the loan has expired, or they can renegotiate an extension if both parties wish to do so. Like I said, a lot of times within the public library world, this doesn't happen too often. Your larger libraries might do it occasionally. More times than not, how you're going to get a collection is through a donation. More times than not, you'll have to decide, do we keep it or not? Suggestion on that is within your policies, make it clear how your donation procedures operate, that you will follow the same selection criteria that you do as purchasing. That way you have that structure in place. That way, if anything's ever challenged, you have that structure in place. You have duplication, that structure's in place. If something is so terrible with mold, whatever, you can't use it, that structure's in place. We always told our donors that all that up front. If they didn't choose to donate, we understand, but they would have to understand that not everything might be used and it might be put out on the donation card for people to take. to add to their personal collections, or if need be, it might be trashed because of the condition. Be upfront with your donors. They usually appreciate that. That way, if they, a week or two later, if they go back and say, there's a bunch of books in the dumpster that came from my father, there was a reason. A lot of libraries you'll see at Ken Library offer up, we got these donated, but we can't use them. Can anybody else? That's another avenue. A suggestion, if you can, get away from this practice, is don't use placards for memorials in items. The reason being is the first time I weeded our collection, we did get rid of some books that had not been checked out for over 15 years. And it was bought with a memorial fund and it had a placard in it. We actually put it out and we had a friends at that point, so it actually went to the book sale. A member of that family, not an immediate member, an extended member of that family, found it, brought it to the desk and said, "Why is this in the book sale? This should be placed back on your shelf." At that point in time, once we received donations or memorials, we always said that we did not state that we would put a placard in it. If the parties wished us to, we would, but that was not a service that we offered automatically. That just avoids a little bit of headaches in the future. If you do have some of those placards within some of your books, usually to avoid hard feelings within the community, sometimes we would take them outside of the community to recycle them either to another library or people that might be interested to put it in their collection. So just a suggestion, don't have to follow it, but it did save us a lot of headaches. All righty, 12/12/28 is the next one. This basically gives you the power as a library to enforce your rules, such as overdue fines, if you still have overdue fines, payment of lost items or damaged material, equipment, or building. And it has to be suitable penalties is how it is described. So you can't say that, okay, we have this book, it's damaged, you're going to pay us $40. Well, the replacement value when you bought it, the value when you bought it was only $30. You can only ask for the $30. You can't do the $40. Now, if you want to calculate in processing fees, that's different. You can calculate processing fees in as well. But the actual material, you can only give the expense of what it cost initially. That's on what you can recover. All right. Anything else at the moment, Robin?
Right now, although I will say this is why we put the original cost of the book in the catalog when we're cataloging it, so that you know how much you paid for it and it's easy to get those replacement costs. But anyway, it's not a requirement for us either, but it's a best practice. And no other questions, no.
Okay. The next one is 12/12/26. This is relating back to your board, specifically your treasurer. Your treasurer needs to be bonded. This helps guarantee the public that the official will honestly and faithfully perform their duties. It is their duty to collect the funds and maintain the library, pay out funds and accept all monies associated, whether it be grants or not. All reality, a lot of times you as a director will be handling a lot of these transactions. You just report them to the treasurer and then they report it to the board at the next board meeting. So that's usually what will happen. Sometimes if you have an active treasurer, they will want to be within the mix and will want to be part of that process. If they do, you can't deny that because they are ultimately responsible. Since I ghosted something different. Also to mention within the treasurer's bond, this is done through an insurance company. Depending on the company that you go to and how they wish to issue the bond, some insurance companies will bond the position. That means whoever comes into that position, you just give them the name and they are bonded. Some insurance companies, like the one I had in Lakin, when I had to do a treasurer's bond, each time it changed, we had to redo all the paperwork for that new individual. They did not do it per position, they did it per individual. So it just depends on the insurance company you're running through, how the bond will look. All right, now some of this budgeting authority, I'm not going to go too much into this because Eric has already done a lot of this for everybody. These are the statutes you need to be aware of: 12-12-19, 12-12-20, and 79-92-25B. The first two are relating to when your library was established and the rules that govern it. The 79 requires the board that is not under a home rule to pass a resolution requesting increase in tax levy. Excuse me. If this is one where when they say home rule, only two entities can be home rule, libraries, sorry. That is a city library and a county library. By statute, townships, regionals and districts, especially since they're elected boards, they cannot be home ruled. However, cities are specific. Attorney General opinion has extended that to counties as well. So counties can be home ruled as well. That is basically where they say, this is where you're tapping out at your mill levy. Depending on how your mill levy is worded will depend on what you will get. If it says, oh, Manhattan Public Library's mill levy is 14 mills, or they will receive 14 mills annually. Technically, by that home rule, Manhattan would receive those 14 mills every year. It should not go down or up. However, most home rules will state, as to some degree or another, can receive up to 14 mills. That gives your city or county the power to kind of wiggle around your budget on you. They can say, well, we didn't have enough taxes come in, so we're under a shortfall, so we can't give you the full 14 mills. Doesn't say we have to give you the full 14 mills, so you're only getting 12 mills this year. That's some of the issues with the home rule. You can challenge it, but this challenge would have to go through a court of law. That burns a lot of bridges. So the board would have to think long and hard before doing that. With 79-29-25B, that is if you are not under a home rule. There are some counties and cities that still are not under a home rule. Technically, before you pass your budget, you are supposed to pass a resolution that to operate your library, you'll need more funding than what you were needing the prior year. Then you go into passing your budget. Now with all the R&R stuff intermixed in there, that's throwing a lot of stuff out of whack. And again, you can request this by statute. They're supposed to provide this, but realistically, sometimes you do not get all of your fundings that you say you need. Again, that is where your library board will have to make a decision if they need to file litigation. And we can skip a lot of this stuff because I just went through it. And then here's the home rule for counties. If we have any counties in there, it's the AG opinion 99-27 that extended the home rule to counties. So let's see. Most of the budgeting authority. Does Eric? Sorry, Robin. I don't know if you were there. Does Eric talk about capital improvement?
He actually hasn't done it yet. He's next month. It's January.
Okay.
He's using Laura's information, and I know she did, so I'm going to assume he does.
So it's in the slide deck. If you want to read it ahead of time, you're more than welcome. Otherwise, I want to let Eric follow through. I'm not going to, the gap waiver, I'm not sure if he covers this, but this is generally accepted accounting principles. Each year in December or before the end of the year, sometimes if you don't have a quorum, an auditor will say, we'll do it in January and fudge a little bit because they realize holiday times is a tough time to get a quorum. Depends on how understanding your accountant is. But this is basically telling your auditor that you're not going to follow the governmental IRS regulations on accounting. you'll become cash basis because your budget is so insignificant to the grand scheme of things that you don't have to follow it. You just do a cash basis. Larger libraries and communities, that can be waived if the governance so chooses, and the auditors as well. So larger libraries like Manhattan, they might allow that or they might not. The smaller communities, though, that's usually, you want to have that gap waiver in place. The audit benchmark is $250,000 in your budget. If you reach that or higher, you automatically trigger an audit to your library's budget or bookkeeping. If you fall under that, you do not trigger an audit. However, if your local government wants you to be part of an audit, you will be part of that audit. So it just kind of depends on where you fall and what your local government says. Let's see, R&R is Senate Bill 13. I know Eric goes on to a bunch of this. That triggers a lot of different things, a lot of different dates. When he's talking about this, pay attention. If you don't get stuff done within the time frame, you will be reverted back to your previous year's budget. So pay attention when he's going through your R&R things. If there's any questions on R&R, I could try to answer them real fast, but I'd really suggest that you wait for Eric because he's going to be the one with more information on that. So this is not intended to step on his toes, but if there's any questions on anything so far, before we jump into Cora.
There's a lot of overlap here because, of course, a lot of our budgeting stuff comes directly from the statute that dictates how we do it. So there is a lot of overlap. Eric will probably talk about a lot of this in January when he does his sessions. But I haven't gotten any more questions on chat except for some specific questions about bonding and what it is and where to go to get bonded. So
It's just an insurance company. It could be State Farm, could be.
I actually found a list of government approved bonding things. So but it doesn't matter. Any insurance company can do it. So, yep.
And because you don't know who you might be going with, our bonding, now take this into account. I haven't been the director over at Lincoln for almost 6 years now. It was only $100 a year. That could have changed since then. Within your area, the pricing could be very different as well. But most of your insurance companies will be eligible to bond your treasurer. It won't be a problem.
Yeah, April says it depends on the size of the budget and for the library and all that, how much you pay.
Okay.
So, yeah.
I think I operated on about a 0.4, not quite half a mil, to 300,000, 200,000. Like everybody else, ours started going down. Anything else?
Nothing in the chat.
Okay, and thank you to April for putting that clarification in there. Do appreciate that. Cora, that is actually the statute 45221. This is Kansas Open Records Act. Might be a little bit of duplication in here, hopefully not too much. Technically, your library should have a designated Freedom of Information officer. And you need to have a form or at least some process, whether it's a written letter, that people can request information that is open under Freedom of Information rules. The reason the library needs its own individual officer is because technically you are your own entity. You are not part of your city or county government per se. Your board is its own operating entity. Some of this stuff is kind of specific. When you get a request, if it takes longer than 3 business days, the library will need to send notice to the person requesting the information that you will need to take additional time to retrieve that information. And then you have to basically put in a specific time and date when they can pick up that information. So that's the tricky part. You have 3 business days to respond to a Freedom of Information request. So when you receive it, either handwrite the date received, or if you have a stamp, stamp it. And then that's when your clock starts ticking, 3 business days. So if it's on a Friday, you got Friday, Monday, Tuesday. If you need more time, you have to tell them why you need more time and when they can pick it up. If you do not meet that scheduled time, they can file a complaint. So be aware of that. You can set limits on how much supplies and time will be at no cost, and then you can start assigning a cost. So if you have, say, your black and white copies are 25 cents a page and you're copying off 4 pages, you can charge them $1. But they need to know that up front. You don't tell them that on the back end. They need to know the procedure up front, what it will be. If within your policies, you're going to charge for staff time, you'll have to average that out and let them know what that charge will be ahead of time so they're not caught unawares as well. So what you can and can't do. This is under statute, like I said, 45-221. Library, archive, and you see the very first word, the library. Archive and museum materials contributing to private persons to the extent of any limitations imposed as conditions of the contribution. You don't disclose that under under CORA. Section 23 of that is library patron and circulation records which pertain to individuals. Pretty much everybody understands that one. Don't discuss any patrons' checkout history. Don't discuss their addresses, phone numbers. Now, 23B is kind of weird. I'll admit that right out the back because it has a double standard, or is contradicting itself, rather. Public agency, which is the key. Public agency or officer shall not disclose financial information to include the name, job description, or title, revealing salary or other compensation of officer, employees, or applicants, or employment with a firm, corporation, or agency. And then at the very end, it says except a public agency. So it just contradicted itself in the same sentence or same statement. So if somebody calls in and wants the name of the position, who's your circulation clerk? You have to be able to give them the name, the title of the position, their description, how much they receive as compensation as well. That is the extent that you give to anybody. If you follow the procedures, they would have to fill out a Freedom of Information request to obtain this information. That is the limit that you give out. Nothing more, nothing less. Let's see. AGP 9564. This is dealing with electronic records. Open records accessed through electronic means require the same written policies as any other. You also have retention schedules. Chris Ripple did one in 2008 specifically for libraries that give you, something might be open in open records. However, if you've done your retention schedule and it was destroyed properly, you do not, you just give them that explanation, saying we cannot provide this information because of our retention schedule. It was destroyed on such and such date. Now, if you still have that, you have not done any retention schedules and have not destroyed anything, you have it, you have to give it over if it is part of the open records. All righty. And there's also a general retention schedule for just state agencies, which in essence, you are considered a governmental agency that you could utilize as well. It's just that Chris's was more geared for libraries and it was approved at the state level to be used by libraries. Privacy issues. The library and staff shouldn't give out personal information. We've kind of discussed that. What you can do, this is the old school. I always love to say it. You can always say if it's in the phone book, hey, go for it. But if not, sorry. Nowadays, cell phones are not usually in anything that I am aware of. And then again, just reiterating the 3 things that are not open to public record. So I'm not going to go through those again. We've already mentioned all that. Now, this is where if an officer comes into your library. If it comes in with a warrant or subpoena, information should not be disclosed to authorities either. So if they have neither one of those, technically you do not have to give up that information. The library has served a subpoena. It gives a time frame when that information is to be turned over to the authorities. Then as also states there, do not exceed limits of a subpoena. For a warrant, that is to be acted on immediately, and again, do not exceed the limits of the warrant. And then there's one exception. If an officer or agent comes in and believes there's immediate threat to property or life, they can take the information. And then they just have to prove to the judge later that there was imminent threat to property or life. So that's one area where they can come in and just take the information. When you're dealing with any of these type of situations, record everything, double check, make sure they are an authority of the law. You can always call the court to make sure it's an authorized warrant or subpoena. They cannot stop you from doing that. You're just doing your due diligence and what you need to do as a part of their job. They might get a little irked at you, but you are there to protect yourself as well as your library board. Because if you don't do things properly, you can come under a litigation suit yourselves. Also, because of litigation, that is why I mentioned that you do not exceed the limits of the subpoena or the warrant. If they are needing video surveillance from 10 o'clock to 10:45 a.m., 10 a.m. to 10:45 a.m., if your security devices have not been overwritten or purged, which should be within your policies when they are purged, you just give them that timeline of video. If you go before or after that, technically in the eyes of the law, the person that you're giving up that information on can file suit against you for overstepping the authority of what you were to give to the authorities, and you violated their privacy. You know, it's weird, but when you're talking about law stuff, sometimes just one little word could change so much. All righty. This is one
Now,
of
Pauline, sorry,
Oh,
Pauline did have a question about board members' contact information and how to make that public. And what I recommend to our folks is that you ask the board members what they're comfortable with and don't
Right.
post anything more than that.
Usually, I don't like to share addresses
Mm-hmm.
if they're comfortable with their telephone numbers. That's
I mean,
give
do
that
we
out.
do we have any obligation at all to make that public? Like, we have the names of the board members, but we don't have an obligation to make how to contact them public.
Within your guidelines with bylaws, you can put a stipulation that, you know, their point of contact is the library. You could forward the message to the board member with the person's name and number so they can get back in touch with them.
Yeah, because they're that's a public body, they really need to be contactable, but yeah, it can be the library, can be the contact point.
The only one that's really kind of up in the air would be your chair.
Mm-hmm.
That individual, more times than not, they allow their phone number to be given. Addresses, no, you don't have to disclose addresses at all. The chair will usually disclose their number just in case of emergencies. What is defined as emergency, different people will decide. But that's how I would recommend it.
Mm-hmm.
Not familiar if there's any statute per se that says one way or the other.
I'm not familiar. I'm not familiar with anything. It's just my sense. It is a public
Right.
trust position, and so there should be a way to get a hold of them. Their whole job is
Right.
representing the public to you. So I feel like there should be some way to, but you know, that's how I feel.
Always have at least that avenue that you will
touch with them and they will be contacted back.
Right,
Then you would
And-
have to follow up on that to make sure it's done.
sure.
Thank you.
Just real quickly, when Richard was talking about warrants and subpoenas, for those of you who have shared catalogs, you're not the owner of that data. So in our case at Neckles, when somebody gets a warrant for information from the catalog, it goes to George. It has to come to us because we own the data technically as the administrators of so that doesn't matter with if you've got your own system, but if you're sharing it, that's something to consider.
It's the same with CKLS. So if you're
Mhm.
part of the CKLS Koha Pathfinder group, if you get any warrants asking for patron information or anything like that, it has to go to Gail.
Sure.
Yep. The,
Right.
the wonders of technology. Anything else before we go on to gaming?
Nothing in chat.
Get over. All right, this is some legislation that was passed 10-ish years ago, I believe. It's 75, 51, 72, and 73. This is in regards to charitable gaming and what it entails. Definitions, you'll see in the second bullet point is bingo or games of bingo, call bingo or instant bingo. Also, charitable gaming is defined as means bingo, including call bingo, instant bingo, and charitable raffles. So here's raffles. Then it also goes into raffle. Charitable raffle means a raffle conducted by a nonprofit religious, charitable, fraternal, educational, or veterans organization. Educational is highlighted in red there because libraries are considered an educational institution. So we fall under the educational umbrella. Now, if anybody ever decides to challenge that, it could change, but at the moment, we do fall underneath that umbrella. So you can start doing, during your summer readings, if you're doing bingos as some of your programs, this gives you the authority to do so. If you decide to do a charitable raffle, you're wanting to help build on to your building, this gives you the authority to do so now. Then some more definitions. You have mini bingo and then nonprofit educational organization. You'll see highlighted in red. Oopsie, sorry. Highlighted in red again, you see institution of higher education. Again, that's where libraries are lumped. So that has made it a little nicer for libraries to move forward and actually do some things that you could not in the past. This is some of your limitations. No license shall be required for any nonprofit, religious, charitable, educational, since it's highlighted, which conducts raffles that annual gross receipts which do not exceed $25,000. If you are fortunate enough to exceed $25,000 in a year in raffles, good for you. Report that and run with the money. That's all I have to say with that. And then the second one, any bona fide nonprofit. I'm going to skip to educational organization that conducts charitable raffles for which the aggregate gross receipts from such raffles in the fiscal year does not exceed $25,000 shall be exempt from the provisions of this section. Because anything else has to be reported to the IRS and your state as well for tax purposes. But if you don't meet that $25,000 magic number, you're pretty much comfortable and safe. All right, that's it before we go into liability things to consider. I know we just stopped, but
Nothing in chat.
all righty. Points of litigation or liable areas that can be open to you as a librarian and board. Acting in excess of authority. So this is removing materials without due process. Imposing unpaid extra hours on staff. Nonfeasance, examples of that, failure to post copyright notices, failure to meet contractual obligations. If many of you are like us as a system, We actually contract with Swank for movie licensing. You have to follow their rules and regulations. And not just the copyright laws, but you also have to follow the company's rules and regulations as well. So bear that in mind. It's kind of like YouTube. If you're doing a podcast that is just up on the web and it's reviews, you can do snippets of music and cover art and snippets of pages. But if you're on YouTube and you're still doing a review, because of their policies, you can't do any of that. And you have to follow their policies because that's what's governing it. So be aware of that with your movie licenses. Negligence, unsafe buildings or grounds. This is where part of the Apple gives you that maintenance check sheet to go around your building to see what's going on. Failure to supervise funds. Also have intentional torts such as libel, assault, improper termination of an employee, and theft. Acting in contradiction to the law, authorizing payment to improper expenses, purchasing property without proper bidding, failing to follow pertinent rules for hiring, conflicts of interest, compensating the board for doing work for the library. We'll come back to that one. Incompatibility of office. A member of the city council may not serve on the library board. We'll come back to that one here in a moment. Yep, okay, that's it. On these two, let's do conflict of interest first. If somebody is bidding on something or it is a board member that happens to be related some way in form or fashion to a staff member, when discussion is being had about that individual or circumstance, they should step aside and let the board discuss that on their own, make that decision on their own. Because if they, as an individual, come in and start voicing opinions and that's actually part of the vote, that could be considered a conflict of interest. You don't want to do that if you can. And also, the way boards are structured, because we had a question about this. Can relatives serve on the same board? Answer is yes, to an extent. If you have a mother and a son that are on your library board, they can both serve on your library board. The main thing that is requested is that they cannot have a majority of decision-making power within that board. So if you have a board of, you need a quorum of 4, because you're a board of 6. 4, for whatever reason, a lot of them are related to each other. If the quorum is of that family, they can't really they're not supposed to be making any decisions because that put them into the majority of the board making a decision. They would have to postpone that until the full board can come back in and balance out those possible biases. Well, it's kind of weird, but it is allowable. For incompatibility of office, this comes into play. Your city mayor or your chair of your county commission is already your ex officio and has powers and duties of a board member. However, other members of that governing body cannot be part of your board. They can come to your board as an observer and report back to that governing body, but they don't retain any power for that board itself. There is some question about department heads, and it's still kind of unclear on some of the decisions I've looked at. If it's a department head and they are paid and not an elected official, if I remember correctly, they can be part of that board. But if it's an elected position, they cannot be part of that board because the power is in the city mayor or the chair of the county commission. So there's some ins and outs that you have to go through when you're looking at your board makeup. One of the things when dealing with your boards, when you have vacancies, before we wrap up, depending on how your local governance lets you do it, they might allow you to gather the letters of interest and allow your board to look over all of them and make recommendations to the city or county or whoever it might be of who might be the best fit for the board. And maybe rank them 1, 2, 3, however many you have. Then you as the director and the board member, preferably the chair, but if not, at least you, advance that to the city commission or county and you have to give them all the names that you reviewed and all the letters of interest so they can review them because they ultimately are the ones that appoint. And you can voice that this is who the board thinks would work best because we are missing this element. It might be, you're looking for somebody that's in their 20s, 30s to represent the younger set of your adult community. And give those reasons. And they might agree to that and appoint that person. They do not have to. They can appoint somebody else on that list, or they might know somebody that voiced an interest and they can appoint that person. So your mayor or your chair can appoint that with the approval of the rest of the governing body. So yes, the mayor and all of them does appoint your board, but it also has to be with the approval of the governing body. If they don't get that approval, then they will have to select a different appointee, and that gets put up to vote for that person to see if they will be put on the board or not. So those are some in and outs with your board. It just depends on how they work with the your local governance on how they want it done. Some boards will say, some of your governance will say, yes, please do all this work for us because they don't want to do it. But some will say, no, we're in control. Thanks for the interest, but no, thank you. So be ready for that. Okay. See, I don't think directors have the protection. Where are we at, Robin?
The only thing I think that's right now is city clerk, which is not elected office, but voted on by city council. Can they be on the board?
To be honest, I would have to look that up.
I'm not sure. I know if they're just an employee, like you said, like the direct or the department head, it's probably okay, but appointed, I'm not sure.
I'm not sure about that one. I'd have to look into it.
We'll find out.
Yeah. I'm not going to say I'll do it this week because I'm about done for the week. I told Robin the story. I won't bother you, the rest of you, with it, but I'm tired.
It's been a week.
Let me write that down so I can look into it and I'll shoot you an answer, Robin. Let's see.
And then I'll make sure it gets out to you guys when I get it. So
city clerk is voted on by the city council. That's interesting. Usually that is interesting. They're not hired, they're voted. Okay. Is that common practice? I don't remember our city clerk ever being voted on. They just hired her or him.
They interview as a council and vote collectively.
Okay. Interesting.
Yeah. I don't know how common that is. I'm not familiar with the process.
Well, I just ran into something at Dodge City that kind of blew my mind. The mayor here is not elected. The city, they're called a city commission instead of city council, but the councilors rotate who the mayor is on a given year. I was like, that's a different twist I'd never heard of before.
That's actually how Lawrence does it.
Okay.
We every year we have a new mayor, and whoever won the most votes in the most recent election is the mayor first, and then the next. So they go by number of votes. It's the most bizarre system I've ever seen.
Okay. Let's see. The clerk Then was officially voted on during the next meeting. That's weird.
Yeah, it is, there is a unbelievable number of ways people can do government in this country.
True.
So.
And that's something within the Kansas Constitution. They give
Mhm.
cities and counties a broad range of, that home rule
Mhm.
can be a game changer any which way.
Sure.
I know this was fast. I apologize. We did get through everything. No, and now you see why I say it's a lot to absorb. Have questions, shoot me an email or talk with your consultants, see if you can contact me. Report to your counselors. Oh God, thinking about law. Talk to your consultants, let them know you viewed this so they know to check mark that off your requirements. I'm not going to pressure you to do anything else. I know it's a lot of information. This is what I do for our local directors when we have new directors here in system. So whenever we have students within Apple, I tell them they can skip this portion because they've already been through it. So, but usually we take a little bit longer. Sometimes this session has taken up to 4 hours because of the questions. So,
Sure. I believe it. All right, I'm going to stop recording